Hi guys, it's Kathy. Today for Best of the Mess, we go back 2 years to Judge Cristofino in Indiana. You can only see this judge on this channel, so you may not have seen him before, but you don't play with this judge, period. So we get a plea deal that's wrecked and an inmate who finds out who's boss really, really quick. Here we go.
Did you understand those rights? Are you waiving those rights? And are you pleading out?
Yes, sir.
Is this your own voluntary decision?
Yes, sir.
Let's go back to May 11, 2023. On that date, were you in Elkhart County, state of Indiana, and did you knowingly exert unauthorized control over the property of Walmart with intent to deprive Walmart of the value or use of any part of that property?
Yeah, yes.
What did you take from Walmart?
I attempted to take a few things, food, nails. My friend had it in her bag, but she threw it. And Walmart, I'm mostly positive they received all the stolen stuff I attempted to take. I'm pretty sure they got all that back, but.
Okay, Ms. Bolin, you want to try? Because so far we got no factual basis. Go ahead.
Yes, thank you, Your Honor. Adriana, on May 11th of 2023, were you in Elkhart County, state of Indiana?
Yes.
And on that date, did you knowingly exert unauthorized control over the property of Walmart?
Yes.
And you did so with the intent to deprive Walmart of the value or use of said property, is that correct?
Yes, ma'am.
And like you just represented to the court, it was food and some other things, is that right?
Yes, ma'am.
And you have a prior unrelated conviction out of Elkhart Superior Court 6 under cause number 20D06, 2209 F6 1203. Is that right?
Yes, ma'am.
The court satisfied with its factual basis, Judge.
Did you take the property without the consent or authorization of Walmart?
Yes, sir.
I'm interested. Did you get the items outside the store?
We was in the parking lot, and my
There
friend
you go.
threw the.
You got outside the store and passed all the points of checkout to pay for the items, correct?
Yes.
Yeah, quit mitigating it. You either want to plead guilty or don't. If you don't want to plead guilty, Ms. Woods, don't take the deal. Do you want to plead guilty?
No. I'd like to go back. No, because they did get all their stuff back.
That doesn't matter. That doesn't matter, Ms. Woods. That doesn't matter under the law. That goes to mitigation and restitution. You want to go to trial? I'll hear a trial on it. I'll get you a jury trial and you'll have a trial. You're going to get no benefit of a deal. You need to understand that. Okay. No.
Okay. I'll
Nope. Okay, that's fine.
Okay.
Please reject it. You can start all over. Let me see if we've got trial dates. We do. You're set for jury trial June 17, 2024 at 8:30 a.m. Do you acknowledge that on the record?
Yes. Acknowledge that.
You understand? If you don't show up for that jury trial, the court's going to hold the jury trial without you.
Sir, I'm currently in Alabama living.
Well, good luck. It'll be a nice trip up here, won't it? If you don't come to the trial, stay in Alabama. You don't have to come to your jury trial. I'll hold the jury trial without you. Do you understand that? That's my question. Do you understand that?
Yes, I do.
So if you want to tell your side of the story, you want to call witnesses, you want to present evidence, you better be in court for your jury trial on June 17, 2024 at 8:30 a.m. Do you understand that?
Yes, I do.
I'll see you back here on May 16th. Good luck, Ms. Woods.
Thank you. Have a good day.
The state of Indiana having charged you with intimidation level 6 felony, it reads as follows. The affidavit, the probable cause affidavit filed here, which swears that on or about January 8, 2024, County of Elkhart, state of Indiana. One, Michael D. Carter Jr. did communicate a threat to Melanie Godden with the intent that Melanie Godden be placed in fear of retaliation for a prior lawful act, and the threat was communicated to Melanie Godden because of the occupation, profession, employment status, or ownership status of Melanie Godden. Did you hear the rights that I read to other people who faced a level 6 felony previously? Were you present for that?
Yes, I was.
Did you understand those rights?
Yes, I do.
Thank you. Let's set some hearings in your case. Well, first let's find out. Hang on a second. Okay, so here you go. You want to yell out and you want to talk when I'm talking. If you want to do that, you're going to get held in contempt of court. and I'm gonna put you at the Elkhart County Correctional Facility for up to 180 days. That'll be without good time credit. That's regardless of what happens in the criminal case. Please don't do that. I'm gonna wait to talk to you and respect you. You've got to respect me. Will you do that, Mr. Carter?
Yes, I will.
Now, you're screaming about a speedy trial. I want you to understand something. In my court, everything's filed with a written motion. So you don't make oral motions. During trial, you make oral motions, but otherwise you do written motions. Okay, so let's start with this. Are you going to represent yourself? You're going to hire private counsel? You want a public defender? What's your pleasure?
From my concern, I already had a public defender represented to me, which is Matt Johnson. So I don't know how you're gonna proceed with that. He's already represented me for several cases, including the level 4 offense that I'm charged with from the same day of January 8th. So I thought that this was going on with this same
Well,
case.
It may, just hang on, it may, but
Okay.
it got filed separate. Let's you and I get everything on the same track. I mean, I think that's what you want, because I think it's best for you. I think you realize that. That's what I want to do too. So let me ask some questions. You want a public defender. If I ask you the same questions you were asked before, relative to your income and assets, would your answers be the same?
Yes.
Court finds the defendant to be indigent and appoints the public defender to represent the defendant. I'm going to try and get these cases coordinated so when you're in court, you're going to be in court on almost everything, Mr. Carter, so you don't have to come back on each case every time.
Is I allowed to speak now, Your Honor?
No,
Mr.
not yet.
Carter, I'll be out to see you before your hearing, and we can talk about everything all at once. That's the right answer.
Now, Mr. Carter, do you acknowledge on the record this case has been set for jury trial October 21, 2024 at 8:30 o'clock a.m.?
You said what date?
October 21, 2024 at 8:30 o'clock a.m.
So that means that you're combining all of my cases together? That's what
I'm trying to get them all set at the same time. That doesn't mean they'll all go to trial on that date, but at least when you're in court, you're going to be in court for all the cases on one date instead of coming back 4 separate dates.
including my probation violation?
I think
your
that-
probation violation is going to be still on March 13th,
Yeah, that's set for March 13.
So,
coming up real soon.
but I still be able to request for my fast and speedy trial on my new cases? That's what I'm not trying to get
That
confused.
is, Michael, that's something that we can talk about.
Okay, but I just don't want to acknowledge a trial date, and if I want to ask for a fast and speedy trial, that's all I'm saying. I don't want to acknowledge that I'm willing to go, understand that you're setting my trial date to September in both of my cases when I was trying to ask for a fast and speedy trial.
Michael, as your attorney, I'm telling you, you should acknowledge the trial date. We will get the information on the new case, and if it's appropriate,
It's too late.
to do a fast and speedy, that's what we can do. But that's
Okay, I'm gonna acknowledge this is on record that I'm gonna go with this, but I'm still gonna acknowledge on record that
Mr. Carter, stop talking. I'm tired of waiting for you to have a consultation with your attorney with me present, which is totally inappropriate. Totally inappropriate, Mr. Carter. Not just for you, for me. So I'm going to handle this another way. I'm not going to ask you to acknowledge it. Listen closely. I'm advising you, your case is scheduled for jury trial October 21, 2024 at 8:30 o'clock a.m. I'm advising you that if you don't show up for that jury trial, your jury trial will occur without you. I'm advising you that if you want to tell your side of the story, you want to call witnesses, you want to present your evidence, you're going to need to be in court for your jury trial on October 21, 2024 at 8:30 o'clock a.m. Now, one final thing. What about bond? Do you want me to get a bond report ordered? Mr. Johnson's shaking his head, yes. Do you want to overrule
No.
that too, Mr. Carter?
No, because you already denied me bonds in my other cases. I'm for sure you're gonna do it in this case too, so I just really ready to proceed with the matter.
Great idea.
No
Yep.
bond report.
The judge is so good. He is super strict. He goes by the law, period. No ifs, ands, or buts. No, but what if, the law. He will give leeway sometimes if there is law to allow him. Like, he is so strict, and he doesn't allow games, shenanigans. Just doesn't happen. So if you want to see more of Judge Cristofino, you have to come here. I'm the only one showing him. I don't show him often, but I do show him, and he's really good. Thanks for coming out, guys. I appreciate it. I hope you guys have a great day. Bye.